All right, there we go. Well, you know, they say that power corrupts and PowerPoint corrupts absolutely, so I'll apologize in advance for that. So to me, the most interesting thing about I'm Craig Aaron from Free Press. We're a national, nonpartisan, nonprofit group devoted to media advocacy. We organize in Washington. We have lawyers and lobbyists and researchers who try to pay attention to what's happening in Congress and at the FCC from a public interest perspective. We don't actually take any corporate money or government money or political party money. And whatever power we may or may not have comes from our members, about 500,000 of them across the country, who we try to organize and mobilize at key moments when they think they can make a difference in these media policy debates. And Sopa and Pipa was one of those occasions. And the most interesting thing to me about this debate wasn't necessarily the details of either bill, though I'm sure we'll get into that a little bit, but it was rather how in such a short time the politics surrounding internet policy making was really transformed. Historically, the way media and technology policy gets made in this country is behind closed doors. It's in the public's name, but without their involvement or consent. And that's generally how the big companies like it. They like to present their issues as far too complex for the average person to comprehend, let alone the average member of Congress. And they spend hundreds of millions of dollars on campaign contributions and lobbyists. The media industry spends more than even the oil and gas industries. All of it aimed at convincing leaders to leave the wonky details to the experts, by which generally they mean themselves. And I think that's generally how Sopa and Pipa were hatched, mostly in closed-door conversations between industry lobbyists and congressional staffers. There wasn't a public debate on the front end because I think a lot of the companies, the movie studios, the record labels, they didn't really want one. They didn't want one because they already had that support lined up in Congress. So they went in and they wrote this bill with the help of some bipartisan legislators, people like Senator Pat Leahy of Vermont, shown here in his cameo appearance in Batman's The Dark Knight. As I noted, not actually a lobbying meeting. But these folks, you know, they were able to round up dozens of co-sponsors in Congress, people willing to sign on to just about anything as long as those campaign checks kept coming. Now, I want to sort of begin by saying that I do believe that piracy is a real problem. I suspect in some of the debate, its economic impact has been vastly overstated, but there is no question a legitimate and valuable debate to be had over how we're going to compensate artists and content creators for their work in the internet era. But I believe that these bills were absolutely the wrong way to do it. First of all, Sopa and Pipa, as they were originally written and even in their subsequent drafts, really threatened, in my view, the fundamental architecture of the internet. I think they would have failed in their stated goal, which was actually stopping piracy or blocking these determined pirates, but they did unquestionably threaten the functionality and security of the system that translates domain names like freepress.net or newyorktimes.com into the IP addresses that computers use to communicate. They propose to fundamentally alter the way that works, and I think that has very dangerous implications. They also would have empowered the Attorney General to create a blacklist of sites to be blocked by ISPs, search engines, advertising networks, etc., all without a court hearing or trial. Under these bills, you were very much guilty until proven innocent. But at the same time, they urged these internet service providers, they shielded them from liability for supposedly voluntary actions that were consistent with the purpose of the bill. So people were essentially being urged to take down content before receiving a court order. And the problem with these voluntary provisions, which some characterized as vigilante provisions, was that they made the copyright holders and the internet service providers into a judge and jury deciding the fate of a targeted site. The courts under these bills likewise would have been able to shutter a site without actually hearing from the accused parties. And I think this was just a glaring lack of due process protection against government overreach that could have very easily led to the takedowns of lawful sites. And I don't believe this is an idle threat. You know, in a now somewhat famous example of mistaken seizure, I apologize for the vodka ad, but that's what's on the front of the site today. The U.S. government officials shut down this hip-hop blog, whose name I will not attempt to pronounce, for over a year, despite the fact that the violations it supposedly committed were based on content that it had actually received from record labels. So the record labels themselves were sending these guys content to push out there, and they wanted them to give it out for free, yet they got caught up in this large dragnet and were shut down. So you have to imagine for a second, as the folks at TechDirt work, if the US government, with no notice or warning, instead of shutting down this website, let's say they would just raided a small magazine. It happened over Thanksgiving. They seized the printing presses. They told the world the magazine was a criminal enterprise, as they did with this site, and put a giant banner, instead of on the front of their website, on the front of their building. But then imagine further, they never arrested anyone. They never let a trial happen. They put everything under seal. And they didn't even let the website, in this case, or this hypothetical magazine's lawyers, talk to the judge presiding the case for over a year before finally realizing they had the wrong guys and handing everything back and pretending nothing had happened. Now, this website was able to survive somehow and continue their business. But for many people, the idea of being shut down for a year, certainly that would not be an option. I think this is a taste of what was wrong with Sopa and Pipa. If Sopa and Pipa had passed, I think what you would see is, you can imagine this world where a YouTube or a Flickr or a Facebook or a Twitter would never have been created because of the legal risk. That was what Sopa looked like. You can imagine an internet where any website where users can upload text, pictures, or video is liable for the copyrighted material that may be posted there. That was Sopa. You can imagine a world where the addresses to the websites that ended up on that blacklist could not be found using search engines. That was in Sopa. And you can imagine a world where the government could require that a website hosting videos of a revolution be taken down because it also hosted videos of Hollywood movies. That was Sopa too. And as the details of these bills started to leak out, word started to spread in email and social media, and what formed was this really interesting ad hoc coalition of strange bedfellows, Republicans and Democrats, policy wonks, grassroots organizers, investors, and tech journalists who started talking and strategizing about this threat. Yet, by the end of 2011, anyone counting votes in Congress would have been sure to tell you this bill was going to sail through. But what's so interesting is that, underneath what people in Washington could see was that outrage was really rumbling at the grassroots. And it continued to grow as Congress seemingly refused to acknowledge or perhaps understand the concerns of its critics. There were campaigns being launched at social networking sites that weren't household names, places like Reddit, that were against this bill and were against companies like GoDaddy.com that supported it, calling for boycotts. And before long, this little snowball that got going started to become an avalanche. And on January 18th, in a truly unprecedented show of strength on the internet, millions and millions of users rose up against these bills, with Wikipedia here, Reddit, boing, boing, thousands of other sites going black to join this protest. Even Google blacked out its logo for the day and drove people to contact Congress. One lesson that we learned in this week was just how much reporters use Wikipedia. Because it took this website blackout for this story to actually enter the public consciousness. Just days before the blackout at Free Press, we were actually running a campaign complaining about how there had been no coverage of these bills happening on TV or outside of the tech press and the business pages. But once Wikipedia went dark, the story was on the front pages and it led the newscasts. And by the end of that day, by the end of January 18th, something like 10 million people had taken action against Sopa and Pipa. By signing a petition, by calling Congress, and this was really unprecedented. And all of a sudden you saw members of Congress who are sponsoring the bill start to jump ship because of the groundswell of opposition. President Obama came out against the bill. All 4 Republican presidential candidates came out against the bill at a debate that night, and it was ultimately shelved. The interesting thing to me is that this was such a repudiation of the way things usually work in Washington. And I found, being somebody in Washington, that it was so shocking that lobbyists started doing something they don't do very often, which is telling the truth. And when Sopa and Pipa fell apart, our friend Chris Dodd, the former senator from Connecticut, now representing the Motion Picture Association of America, he, sorry about that. He said this on Fox News, and he said, those who count on Hollywood for support need to understand that this industry is watching very carefully who's going to stand up for them when their job is at stake. Don't ask me to write a check for you when you think your job is at risk, and they don't pay any attention to me when my job is at stake. And this is kind of an amazing quote because it's so rarely that you hear an honest expression of how Washington actually operates. And after Sopa and Pipa fell apart, Dodd tried to propose a latch-to summit at the White House between Hollywood and the internet companies. But more closed-door meetings, I think, is exactly what the anti-Sopa folks were fighting against. And even today, the MPAA and its allies, they continue to slander this whole effort as just some kind of front for Google. When really Google got into this game much later. They got in front of a wave that was already moving forward, and they like to increasingly blame the media for overhyping the whole thing. So, in other words, from my perspective, they still don't get it, and they don't understand that their opponents in this fight are actually their audience, their customers. And I think that this is a real wake-up moment that their approach to politics, much like the business model, desperately needs to adapt and change. Now, still, there are others who will paint Sopa's defeat as evidence that we should have no rules at all. But I don't think that sort of purely libertarian perspective is right either, because we're going to have rules. There are going to be rules, and the only question from my perspective is, who are those rules going to benefit? Are they going to benefit just a small handful of companies, or are they going to benefit the vast majority of internet users? And that's, I think, the public debate increasingly we need to have in the fallout from Sopa. And that politicians putting forward good policy, I'll wrap up, will have widespread popular support. So last thing I'll say is this much is clear. There's no question the Sopa backlash got Congress's attention. This is Politico, the Hill Trade Journal, and the warning apparently going around the Hill right now is don't get Sopa'd, which isn't a total victory, and it will always be harder to make good policy rather than throw a wrench in a bad bill, but it's a hell of a start. Thanks.
Thank you, Chris. Thank you, Craig. So we'll now hear from Stanley Pierre-Louis.
Yeah, I'll just do it from down here. Hi, I'm Stan Pierre-Louis, and I'm with Viacom. I always look for some point of agreement when I'm on a panel or when I'm in a debate with someone. And so I did note two things that he said, that Craig said, that may resonate. One is that piracy actually is a problem and we need to address it. So that was one point. I caught that in there in the soliloquy. So thanks for that. The other is the bill that he described sounded terrible, and I would not support it. Unfortunately, there's a lot in there that he described that isn't quite accurate about how the bill was, and so that wasn't really the bill. But before we talk about what these bills were, let's just take a step back and just talk about what some of the industry concerns have been, what their approaches have been, and to the extent that I can talk a little bit about the media reactions to it or impact on it, try to touch on those. Prior to the digital explosion, sort of late 90s going into the early 2000s, there probably wasn't a lot of news about a lot of the work that, on the anti-piracy side, that studios and recording companies and other media industries were doing. Playboy, for example, probably filed more cases than anyone in the 1980s against bulletin board services, and won every single case every time someone was posting photographs. And the same was true in the early cases with recording companies and music publishing companies. And whether it was a business, showing NFL games without a license, or flea market selling fake CDs, there was no real communications issue. And there was no real legal issue because these cases generally went one way. I think the digital explosion sort of did two things. One, it made the accessibility of content freer than ever. And so it wasn't someone sitting with an old tape deck and a radio and pressing record and taping something on an analog. You had digital to digital, and you had wide accessibility. So one person could send to someone else or even file share with someone else. And so I think this legal accessibility or free accessibility got conflated with what was legal and morally acceptable. And so we don't think about those things, but those are in the background of how we act and what we do. And I think when you couple that with the proliferation of services that fed on those, that sort of accessibility, it changed the dynamic. So when you have a company like Napster come out and say, oh, here's a way to connect without licenses and doing things that companies with licenses could not do, you change the marketplace, but you also change the debate because you have this free accessibility that people have to the content. And so that gets conflated with, well, free accessibility must mean morally okay because I can listen to the radio for free, and so I can download for free, and I can share with someone else for free, and I can, make CDs and sell them to other people for free. And I think there was a debate there that started. From a legal standpoint, these cases pretty much went one way in the early rounds. Those who started those kinds of services, those who started those kinds of devices, and even CD plants that were pressing CDs from works that were made from that kind of free accessibility were all found liable. So from a legal standpoint, there wasn't a lot of questions. There were questions during the cases, but once the decisions came out, I was talking to this law professor maybe a week or two after the initial Napster decision came down, and she said, we knew it was wink, wink, nudge, nudge software. Like we know it was illegal, but there was a debate, and it was fun to have the debate, but the courts sort of decided the issue, and we kind of get it. But I think as that accessibility grew, it became a tougher communications matter because on the legal side, you're really focused on the defendant before the court, as a plaintiff. But in a public relations sense, it's a much different debate because everyone has access and they're out there on the internet and using systems and using devices. And so how do you square the fact that you've got a legitimately purchased device that allows you to acquire content in a way that doesn't require payment, and yet someone is telling you that that's wrong? And all the while, the courts are saying, yeah, that's actually wrong. And I think that's been one of the juxtapositions. That strong legal system did a couple of things that had negative consequences on industry. First of all, we have a strong court system because our laws sort of tell you what you can and can't do, and there's fair use, and there are questions in there, but I'm going to think about the laws as a broad thing. We have a court system that you can rely on, and we can enforce judgments here. If you don't do what you're supposed to do, if you don't comply with a court order, if you don't pay a judgment, the law you can use the court to enforce those judgments. In other countries, that's not always the case, and so what you found was many of these sites moving offshore, because if you went to a jurisdiction with a weaker law or a weaker court system where a place that doesn't enforce judgments, you can get away with a lot more. And as broadband grew and as accessibility to content in all kinds of locations really started to grow and get faster, you had a situation where it became a lot more, you had a situation where sites moved offshore because it became easier for them to do what they were doing. And that left US companies with a problem. We still produce probably the most popular content in the world. And obviously there's great content that comes from everywhere. But the way we market our content, the way we get it out there, the way we distribute it, it really is second to none. And that's what they're feeding back to US consumers, but they're doing it from other locations where it's harder to enforce. That's really where Sopa and Pipa grew out of. So all this talk about we're going to shut down Twitter and Facebook that you heard in the prior presentation. None of that was really part of the discussion. When you look at Sopa and Pipa, and I'm going to speak about them broadly, although there were some differences in there, they're really focused on offshore sites dedicated to infringing conduct. And so when you're looking at sites that are taking wholly infringing works or works that don't have a license, and many are in theaters now and they're not available for sale to the public in any other way, and they're offshore, you can go to court, you can get a judgment against those services. But what happens when you get that judgment? you've got to figure out how to enforce that judgment. And if the limits of our court system are the U.S. borders, then there's no way of enforcing that judgment. And so you had a situation where, people put their heads together. I know, and I'm going to get to all Craig's points about, whether this was really behind closed doors, no hearings, no due process, because all that's wrong. But you had a situation where the solutions that were proposed were, cut the service off from U.S. access and cut their money off from U.S. sources. Not shutting down the site, not taking it down, not having a debate about how much of the site is infringing versus not infringing and how much to let through. It's, if this is a site dedicated to infringing conduct, what are the things we can do? One solution was the DNS blocking, domain name blocking, in which you would block access to the site from the U.S. It's still available all over the world, except for the U.S. Block it from getting into search engines, have them remove it from those queues, because that's where people find it. We live in a search-based society now. It's not that people are always typing in the name of the, the sort of URL of the domain name they're seeking. They're searching for it, and then that's how they're finding it, and they're getting it. So block that access. How are they making money?
Can I ask you a question? I'm going to use my moderators.
Absolutely.
One of the things that I'm interested in is internet policy in other countries affecting American suppliers, and how to prevent them from doing just these kinds of things on grounds of destabilization, on political grounds, et cetera, et cetera. So one of the things that was interesting to me in the debate was whether whether the Congress would be legitimating approaches that could be used, would be used, and should be used by other governments to do things that they thought, like, well, we're not so interested in piracy, but we're interested in, I don't know, anti-monarchical speech or insults to the king or something like that. And so we'll pass a statute that's modeled on Sopa and do these kinds of things. So it seemed to me one thing that was at stake was this principle, and I could be wrong about it, but I was going to ask you about that.
I think one of the interesting things there is Sopa did not introduce, in terms of the domain name blocking, it did not introduce something that was new. In fact,
I'm not talking about new, I'm talking about legitimated.
But it's been happening on a number of fronts. For instance, spam gets blocked.
So does that mean we should be more tolerant of other, which I might think is a good idea, more tolerant of other countries saying, well, this is not new and this is something that is a problem for our country, and so here's a mechanism that you've given us some greater insight in how to do it, et cetera, et cetera.
This would be a great question after it finishes.
No, I'm gonna work it in, because I think if I get through these points, that answer, because it's hard to do the bumper sticker answer on it, but I think I'll be able to answer it. So the core here is cutting off access to money and cutting off access to the sites. And why the money? Because these are not hobbyists anymore. These are people who actually run businesses. I don't know if you heard about this mega upload site where there's been an indictment, and the government in its complaint or its indictment estimated, I think he made $175 million in revenue over, since 2006. 125 million from ad revenue, 25 million from subscriptions, using PayPal accounts and the like. And a lot of that is based here in the US. And so if you're cutting off access, that's another deterrence. One of in fact, the person who created the spam blocking that we talked about earlier, a second ago, basically acknowledged that this does not break the internet, right? What we were proposing in this legislation. This was a public policy debate. Is blocking spam at the same level as blocking infringing conduct and other kinds of conduct? So to those kinds of engineers, this was really a public policy debate, not really an engineering debate. Just to talk about the points that Craig mentioned, he said there was no public debate, this was all behind the scenes. There are actually at least 3 public hearings on this, and as I understand it, lots of people talking behind the scenes, not just industry in some closed room, but lots of people, industry on both sides, public policy groups on both sides. So there was a lot of that. We talked about changing the function of the internet, which this doesn't really do, and also just to distinguish between the domain name blocking and the ICE seizures that were mentioned. The seizures were actually a much different process where you're not blocking the domain, but it's actually being taken by the government and run by the government. So those are really 2 different kinds of procedures, so those should be conflated. But to say that there are no hearings in this process is kind of farcical, because if you look at the language, the Attorney General has to go before court. The other side has to have notice. If the side decides not to come, because many of these people don't want to avail themselves to U.S. jurisdiction, that's on them, but they certainly have the right to come and appear before the court. You've got to prove the case, and only after court order do you start blocking domain names. So I think that's a distinction that's important to make.
I have one other question, which is, I thought you raised a really interesting point about norms. That is to say, what's the relationship between law as a way of determining what people should do and norms? And the relation, law certainly influences norms, but there are other things that influence norms. And one question would be, how did this debate, do you think, affect norms in the country?
Well, I actually think that there's been a lot of interesting post hoc discussion about what happened here. And as you heard from the presentation by Craig and what I'm saying, there is a definitive difference of opinion on the facts. Like I think you honestly believe this was going to block free speech, and I don't. And I think from a legal standpoint, it would not. But that does not mean that by hearing so much of the debate about speech and censorship and breaking the internet, that it doesn't influence public policy. And so then it becomes a question of how do you communicate your message in a way that, while legally correct, needs to be explained in a way that the public consumes it as it's intended, as opposed to as it's characterized by other groups. Because even now, I see other groups. There's like a proposal now by one of the opponents on the Hill, with, oh, let's just block the money. So like they're sort of going partway back and saying, well, we can do something about it. So all of a sudden, you're seeing some outreach efforts to try to block what's going on because there's a recognition that there's a problem. But I do think that how you message what you were trying to enact is very, very critically important. And clearly here you had there were stories on the Hill about phone calls from dozens of people who had never read the bill, knew nothing about it, but were outraged that Congress was going to break the internet. And when a staffer would ask a question back, they wouldn't even know what the bill was. The caller didn't. And so I think you had an instance where the messaging could have been stronger to try to influence those norms that it would have been passed.
Yeah, I guess there's influencing the policymakers and also influencing the mass public. And so this seems to me the big issue, which is how do you change behavior in the public, or how do you influence behavior about exchanging or paying and things like that? So we'll go ahead with Mr. Clement. Professor.
Oh, could you, someone start my overhead as I walk up?
Pardon?
I said, can someone start my overheads as I walk up? But perhaps I can. Okay, I don't want that one. All right. Show me. That's me. Yep, looks like me.
Say, while he's queuing up, anything more about this enormous question? I think it ultimately, it's a great question for us, school in a way, which is how does all of this affect human behavior in some way?
That's, I guess, a lot. I mean, I don't think the problem with SOPA was a messaging problem. I mean, I'm not saying that the proponents of SOPA did a good job messaging, but it seems to me that the lesson we should take away isn't that, this was just a failure to communicate what was in the bill, because, I mean, we can go back and forth probably for longer than anyone would want to sit through listing the dozens and dozens of engineers, including people who helped start the internet that raised the same serious questions. We
but how many of them actually read the bill? How many of them actually
How many of the law professors and engineers read? I think they probably all did. Now, did every caller to Congress read the bill? No. Did every member of Congress read the bill? Probably not. But that's, I mean, for better or worse, that's how our democracy operates here. And so one of the ways that people get involved in participating in the process is they go to their trusted resources to help them interpret what's in the bill. And I guess my argument is that it wasn't a messaging failure of the proponents of SOPA. It was actually a specific strategy to not engage the public in this conversation because they couldn't make the case. But I don't want to take more of your time.
Anytime you want. I'll get started. Okay, I do a lot of writing for Huffington, And I figure congressmen and senators are really smart people, willing to think about nothing for more than 10 minutes at a time. So I think my overheads probably are based on my Huffington piece, as I think it's the right frame. Okay, for those of you who want it in one slide, piracy is bad. Piracy is theft, and most of my students don't think that downloads are piracy. Censorship is bad, and many of my students view any attempt to limit any use of any and all online information as essentially what the Chinese government does to Falun Gong. I pointed out we don't shut down websites here because we don't like the message, and we don't sell off the organs of people whose messages we don't like, so it's not exactly the same. Cowardice is bad, and whether or not you think Pipa and Sopa had an adequate discussion, the reaction in Congress was pretty much brave, brave Sir Robin, which was run away and hope we can have a safer discussion perhaps after an election and long before the next election. I think dialogue is good, though I'm not sure, listening to the first couple of speakers, that we're going to have a lot of overlap on which we may have dialogue. Let's see where we go. So is online piracy really theft? Yes, by definition. If you're using other people's property without authorization, that's theft, whether it's physical goods, intellectual goods, or theft of services. Does theft really harm the owners of intellectual property? This is much more complicated. Record companies and movie studios claim to be losing billions of dollars and lots of jobs. Other analyses claim that piracy by fans creates even stronger interest in the works of artists, leads to even greater demand for ticket sales, which is where the money really is for the artists. This is complicated stuff, but there's even more complicated stuff, which is, does the harm matter? Even if harm to IP owners can be shown, is the harm important? IP law was never intended solely for the protection of IP owners. IP law goes all the way back to the Constitution. It predates the Bill of Rights. Benjamin Franklin, founder of the school, did not approve of IP protection because he thought we did intellectual property development for the fun of it. Congress decided that we needed something to provide incentives, and those incentives were protecting the ownership of the creation for a reasonable period of time. Instead of getting shorter and shorter, it appears to be getting longer and longer, which may be exactly backwards given the change in technology cycles. Things have changed in lots of ways. Mashups and downstream or derivative works are more important than they've ever been. One of my students plays an instrument he invented called the cyber horn. He plays a great trumpet, a great flugelhorn, but he steals other people's waveforms, and he can be Louis Armstrong, or he can be anybody he wants. Now, what this means is I've got a student, fairly good computer scientist, who can create really interesting, really new IP to an extent that Louis Armstrong never could have done. So we really do need to understand the changing economic trade-offs created by the increased possibility of truly valuable derivative work. Okay, if derivative work is more valuable, should IP protection be eliminated? Of course not. I mean, if nobody was doing the original works, we would have nothing to mash up. You can't make mashed potatoes without potatoes. You can't do derivative work without the original work, without great composers, great writers, and great performers. There would be no music, lyrics, or waveform to use as the basis of a mashup. And similarly, I have students who walked in and expressed not just horror, but revulsion to find a purchased copy of Photoshop on my desk. I hate to think of what the student would have said if he'd seen the package underneath it, which was another copy of Photoshop, because I have more than one computer. Guys who do IP for a living are in favor of guys who get protected when they do IP for a living. Okay, so IP protection is okay now, because no. Even if we need to make some changes, or even if we think that they're not entirely balanced, or maybe if we think we're under empowering mashup, some protection needs to be retained. Although it shouldn't be left where it is. Creative reuse should be permitted sooner. So I think, for instance, lifetime plus 70 years is absurd. For the New York Times, protection of an article should probably be 24 hours. For The Economist, it should probably be 7 days. For a movie, I don't know, maybe 3 years. But definitely, if mashups are more valuable and society benefits more from mashups than it used to, then we need to make mashups and reuse easier. On the other hand, if we can't do mashups without the original, we need to provide reasonable incentives for people to do the original. Okay, so we want some protection. Is the bill necessary? Isn't everything already in the Digital Millennium Copyright Act? Well, the existing law evidently doesn't satisfy anyone. Too much is declared to be illegal. Too much is restricted. Too much illegal use is happening anyway, despite the law. And something new is required. Sopa attempts to provide that something new by preventing rogue websites from being found or getting paid. And that seems to be the least obnoxious thing that I could imagine. But Sopa addresses enforcement. And enforcement is not where we need to start. We need to fix the policy. When I was younger, I had friends, this is in the 60s, who went to school at Exeter. And yes, they did inhale. And one of the things that the Attorney General's kids found really useful is to smoke with someone whose dad wasn't in the cabinet. And the idea, if you're going to bust the Attorney General's 3 kids and you have somebody else to throw under the bus, throw somebody else under the bus. In other words, our response was not to find a way to live with drug laws we thought were silly. Our way was to find a way to escape prosecution for drug laws that we thought were silly. If copyright law today is not seen as legitimate, if our students don't see copyright law today as legitimate, they're going to work around it. Enforcement isn't what you need to start with. You need to start with copyright law that we all can agree on. Okay, did I just say the bill is okay? Of course not. It's hard to figure out exactly how a website can know in advance whether it's safe or not. There are websites that know they're not safe. There are others for which fair use or political parody may be more ambiguous. The permitted punishments may on occasion be extreme. It may not be clear exactly what punishment can be applied or when. Laws need to be clear. The use of force needs to be appropriate. I can use lethal force if a naked man is discovered in my 4-year-old daughter's bedroom. I cannot use lethal force if a 4-year-old man is stealing her tricycle. I'm sorry, if a man is stealing her tricycle, unless she's actually on it. So punishments need to be clear, unambiguous, and appropriate. Is this censorship? Absolutely not. Stealing a car is grand theft auto, and preventing someone from stealing a car is stopping theft, not censorship. In the United States, you can say anything you want. Donald Trump, one of our famous graduates, did this birther thing for months, and then even after the documents that he said couldn't be found were found, he decided they were photoshopped. In the United States, you can say anything you want, no matter how offensive, no matter how banal, as long as you say it in your own words. And yet, my legal friends, my lawyer friends, assure me that uncertainty can have a chilling effect. If a law is ambiguous, if you really don't know if what you say is going to be prosecuted or unfairly prosecuted, you censor yourself. And that is a form of limitation of free speech. It's not politically directed the way traditionally censorship would be interpreted, but if a law is sufficiently ambiguous to result in restraint, self-restraint, that may be unintentional and a form of censorship. Okay, last question. Is piracy good or bad for creativity? My dear friend Jaron Lanier, absolutely amazing man, full professor of computer science, never started either an undergraduate or a graduate degree, writes ballets, writes operas, made his first $250 million when he was 21 years old, and lost it before he was 25. Really interesting guy, asks questions like, hum 4 bars, listen to 4 bars of a piece of music, and you can tell if it's written in the 40s, the 50s, the 60s, the 70s. Listen to 4 bars of music from the past decade, and what decade is it from? He says we live in an artistic era without soul. Every technology from woodwind and percussion instruments, which go back 30,000 years, to cameras and talkies more recently, every technology has changed our art. What's the breakthrough creative entertainment of the 2010s? I think it's World of Warcraft. I think the most creative people we have are in fact finding easy ways to make lots of money, taking other people's content and sticking ads around it. And I think piracy and the ease of derivative work, legal and illegal, may actually be limiting rather than enhancing true creativity. In summary, it's complicated. I think I found something Craig and I agree on. Sopa and Pipa are not the solutions, but a solution is needed. Copyright and IP protections need to be fixed first. Once we know what we're going to permit, then we can figure out how to enforce it. Thanks for your patience.
Kartik?
Hi. So just so you guys know where I'm coming from, I used to be a software developer. Most of my research over the last 10 years or more has been focused on internet commerce. When I was a PhD student, I worked on a startup. A few years back, I had another internet startup that I founded. So it should come as no surprise that in the software guys versus the content guys debate, my view has historically been very pro-software. Although I'll say that it has changed a lot in the last 4 or 5 years, and I see myself more as a moderate or a centrist in this debate now. So the reason this changed is that a few years back, I was approached by a law firm they were asking if I could serve as an expert witness on behalf of a large media company that was filing a lawsuit against a user-generated website called View. It's VEOH. It's not the Viacom YouTube lawsuit. But, you know, it was an interesting case. They were willing to pay a lot, so I figured, let me explore this. And I spent a lot of time trying to view this from the content owner's perspective. And in the end, you know, the debate boiled down to the content owners saying that the UGC sites were not doing enough to identify infringing content. And the UGC guys were saying that we are following the DMCA, and in particular that they were protected by a safe harbor provision called 512C, which is a safe harbor that says that if you store content on behalf of a user, you're not liable if you do things based on the user's directive, like store it and offer the content to somebody else and so on, as long as you take it down once you're informed that it's illegal. And the website did that, and so they were clean as far as the safe harbor provision was concerned. And furthermore, these guys were also, they had ample evidence that they were doing enough to detect infringement. So I found it pretty convincing, and I actually turned down the case. But it made me think a lot about the content owner's perspective, that you make all this investment in content, and ultimately, if you cannot monetize that, it reduces investments in content, and everyone is worse off. And it made me think a little more about the problem, and my conclusion was that the problem, that it's a fundamental problem that ultimately legislation cannot solve. Legislation is not the solution to it. It's a market problem, and there has to be a market solution, and that law ultimately can sit on top of a market solution, but it cannot replace a market solution. So let me talk a little bit about that. But before I do that, maybe I'll just get the Sopa Pipa bit out of the way. Because I'm not going to talk much about Sopa and Pipa. So my view is, of course, anti-Sopa and Pipa. I'm not in favor because it's vague, as Eric said. There's the potential that it could block domains, entire domains, which are user-generated content domains, just because one user infringes. And this is a foreign property that you could now claim they're not following our law, so just let's block the whole thing. It bypasses the DMCA safe harbor provision. It eliminates entire domains. There's the whole issue of censorship as well that comes up. But ultimately, the biggest reason for me is that it creates a power imbalance. It gives too much power to one side, which is the content owner side. I mean, I can imagine a conversation where the content owner says, get this down. The UGC side says, we've done all we can. But the content owner can pretty much say, all right, now, this is the time when I report you or something like that. I think it's too one-sided. But anyway, going beyond Sopa and Pipa, I think the fundamental problem here is that incentives are misaligned. So from the copyright holder's perspective, their view is that they should not bear the cost of policing policing who infringes content, and that the high cost involved in detecting infringement should be borne by the companies that are profiting from it. So it's a legitimate argument. It should be borne by the UGC sites, given that they're profiting from distributing this content. Now, the UGC sites perspective is that it's expensive to police, and if the content owners who know their own content cannot police this, it's much harder for us to do. And we all deploy detection and fingerprinting software, but at the end of the day, there is no software that is 100% accurate in terms of detecting infringement. So there's always going to be some content that's going to get away. So the question really is, what can you do here? So the problem is that how much ever these guys invest, you can never get infringement totally out. And so they could always be liable if they don't have the safe harbor provision. They could always be liable because somebody could say that they have content that's infringing and they didn't do enough. So to actually test this and to see how much are different sites doing in terms of preventing infringement, about 3 years back, I did this small study with a couple of my students. It was only purely for scientific purposes. I had them upload some infringing content and I had them remove that content 30 days later onto 4 UGC sites. And we wanted to see how many of these sites detect infringement and how often do they detect infringement. And the detection rates for these very popular 4 video sharing websites, these were copyrighted music videos, copyrighted movie scenes, and TV shows, and so on. The detection rates were at the low end 32% for one of the sites, 50% for another, 60% for the third, and 87% for the fourth. The website that had an 87% detection rate was MySpace, which was also owned by a media company at that time. Now, what is interesting is that the company that best internalizes the costs and benefits of infringement, meaning it's a UGC site, it benefits when consumers get content, can share content with each other. It's also a copyright holder, it hurts when copyrighted content is distributed. This firm should probably be more or less, best situated in terms of internalizing the costs of the whole industry as opposed to one firm. And it did suggest that the others are not doing enough, especially the 2 companies that were well under 50%, that they were not doing enough, and if there is an incentive problem here. And ultimately, the core of the issue is that what you do in terms of detecting infringement is private information. It cannot be observed by anyone else. And you can say, I'm doing all that I can, and the other firm can say you're doing nothing. And the problem for a third party is, who's right? I don't know. And this is a private information problem. And then, it made me wonder, what are some solutions to problems where, private information can lead to market failure? There are a few, and one that I'll mention, given, we don't have a whole lot of time, the one that I'll mention is auditing. I think auditing is a pretty reasonable market solution here, where a firm could have its fingerprinting and detection software be audited on a regular basis, quarterly, annually, what have you. And that the auditor is not only auditing the software, but is also doing random testing on the software to detect, just like we did, how often are you detecting the software. So you can benchmark how often does it correctly identify infringing software, how often does it incorrectly identify infringing content, and so on. And you could establish standards in terms of what is a reasonable benchmark, what is the minimum level of detection one must achieve. And I think that's the better solution than to say that, you have the UGC side's perspective, which is we should have safe harbor provision. Ultimately, the user is liable, goes through the user. As long as you tell me, you do the policing, you tell me, I'll take it out. And then the copyright holder's perspective, which is you're profiting from all this content, you have therefore the obligation to detect it. And I think it's better to address it through some of these other things like auditing, and then add a layer of legislation on top. And I think the layer of legislation on top, I don't think it should be like Sopa or Pipa, but certainly the DMCA needs overhaul, because the DMCA was created in 98 or 99, and it was pre-Web 2.0, pre-user-generated content, so it was not really meant to address these issues. It was created to protect internet service providers and email service providers when their users deal with some infringing content, and they should not be liable. So there is a need to overhaul that, but I don't think Sopa Pipa is the solution. And further, and the last comment I'll make, just repeat myself here, that I don't think legislation is the end goal here. It should come on top of some other market solution.
Great, well, thank you all, and thanks for having me. My name is Beth McConnell. I'm the Executive Director of the Media and Democracy Coalition. We're a coalition of over 30 nonprofit public interest groups in Washington and around the country that have come together out of a common vision for media and communications policy that advances more democratic and just values, as well as openness and accessibility. I'm also a Penn student in the Urban Studies program. So we've heard a lot, I think, already from the other presenters about the policy in Sopa and Pipa, so I'm not going to get too much in the weeds on that, but I imagine we'll have a lot of discussion during Q&A. What I wanted to kind of focus on a bit is how I see this debate as about the fundamental nature of the internet as a platform, and maybe some thoughts about what the fight means for the future of policymaking on internet policy. Now, I do not at all see this debate as a way it's been painted as a debate between artists who create work and people that want to steal it. That wasn't at all what I saw from my vantage point in Washington or as part of this national movement of public interest groups that engaged in this. Part of the reason is because people who steal tend to not engage in policy debates. They just steal, and it doesn't really matter what the law says or what the policy is. And they're going to continue to do that. And I think it's an important point that many have made also about Sopa and Pipa, is that the bills would have been completely ineffective in stopping those sites that are specifically set up just to facilitate theft. That the DNS blocking measure would have been completely ineffective, and those sites are savvy and smart enough to be able to get around it. The question was really more of sites that were not set up to necessarily engage in theft, but may or may not have a user-generated content that may or may not violate intellectual property. And I think one group of folks that were engaged in this fight, and a large group of artists as well, they see the internet as this massively powerful tool, again, particularly for artists and their audiences to be able to connect with each other. That is also particularly true for artists that tended to not do so well in the pre-internet years, when you needed a big record label or a Hollywood studio in order to get your work seen or heard. But now, through the open and decentralized and user-generated kind of values of the net, they're able to, they have new platforms to reach people. And it's why you saw a lot of arts organizations like Fractured Atlas, Future of Music Coalition, National Alliance for Media, Arts and Culture, opera groups, dance groups, filmmakers, musicians, hip-hop artists, telling members of Congress that they were concerned about how the bills could lead to the takedown of their completely legitimate content. They use the word censor, of course, because when they see their content is completely legitimate and lawful and it's taken down, they see that as a form of censorship, kind of in a way of using a blowtorch to kill a gnat. And there's a number of other organizations like Free Press and the members of the Media and Democracy Coalition, which Free Press is, and other groups that see user-generated content has made the net what it is. It has made it the revolutionary tool that we have. Every time someone posts a video on YouTube or gets their song up on an MP3 site, whether it's iTunes or another, Spotify, or shares an image on Flickr, this is an incredibly powerful tool that's made the internet valuable economically, not to mention civically and educationally. Now, I would argue there's another group of folks that really have seen the internet since its early days as a threat. This decentralized network of user-generated content is a threat to their control over our creative economy. And so that's why I believe you saw entities like the Motion Picture Association and the recording industry, really, they've always approached the internet as a threat to their business model, and really, they almost had to be forced to accept the development of the internet and engage in deals with companies like Spotify and Netflix. Those negotiations weren't easy, and Spotify and Netflix had a really difficult time, and still continue to have difficult times negotiating fair use and licenses for that content. Now, I think what we've heard here, and we've heard it from everyone, and I think it bears repeating, is that both of these groups of people agree that artists deserve to be compensated for their work. I think both of these groups of people, at least the ones that we saw engaging in the debate, believe that there's a place for copyright law, and that while intellectual property theft is not wasn't born with the internet, it certainly has made it easier. But to summarize, again, I see it as a debate between a group of people that cherish this decentralized and open nature of the net as their economic business model, and a group that would abandon those principles in protection of a very different business model. The second point I want to make, or I think maybe more appropriately question I want to raise, is whether the claims from Hollywood that the entertainment industry is being devastated by illegal file sharing and online piracy is legit. There's a recent study that offered some data. It said that the worldwide entertainment industry actually grew from 449 billion to 745 billion from about 98 to 2000. Over a similar 10-year period, employment grew by about 20%. And in particular, the largest growth in employment were among independent artists. The number of songs and films and books that were created grew by leaps and bounds over the last 10 or 15 years. So clearly, people are spending more money purchasing and consuming legal, legitimate entertainment content than ever before. And they're doing a lot of it on the web. And they're doing a lot of it and they're increasingly doing that not through the traditional Hollywood studios or large record labels. So I think it raises a question, and I'm not saying I know the answer to this, of how much of the loss that we're seeing from big studios in Hollywood in revenue is because people are spending their dollars elsewhere. I'm sure that there's still economic loss from piracy, but I think more data is needed to really understand how much of that money is just moving someplace else. And the Future of Music Coalition has also argued that point. They say very little data also exists that looks at actually how musicians are making their money now. And without that data, we can't have an informed debate about intellectual property law on the internet. So they've actually launched a research project, and I would encourage that you check out. They're starting to release some of their data. It's on their website now. And this research is on artist revenue streams, so you can see where they're actually making their money. I guess the last point I want to make, and maybe this sounds a little trite, but I think if you care about the debate over Sopa and Pipa, I think you should also care about the debate over net neutrality. And many of you, I'm sure, understand that. They're fundamentally two different issues. But where I see the intersection is whether a government, through a court, gets to decide what content is available to us on the internet, including capturing up perfectly legal, legitimate content, and whether a corporation gets to decide what content it wants to see on its network, including potentially blocking perfectly legal and legitimate content. I think it's about questions of where the public and the consumer, where the public interest fits in policy, in debates over internet policy. And I think that's the biggest takeaway, and I think Craig hit on that way more eloquently than I did in his presentation. The biggest takeaway from this is moving forward in Washington, I think some people got the pants scared off of them, and I wish we could replicate what happened on January 18th with the internet blackout on every level of internet policy that has that significant of an impact on the way this incredibly revolutionary, economically, educationally powerful, and politically powerful tool is regulated or not, as the case may be. So with that, I'll wrap up since I know we want to get to the Q&A. Thank you for having me.
Okay, I'll open it to questions, and then if there aren't any, I'll ask them. But go ahead. Does anyone have a question? Is this a quiet, subdued crowd that isn't part of Free Press? Yes.
I have one question. With regard to the idea that we already employ these sorts of tools, and I think the gentleman from
Stan.
mentioned spam filters. I mean, it seems to me the difference with spam filters is that the user can turn them on and off. So is it a fair comparison really to make?
Oh, I wasn't talking about spam filters. I'm talking about on the internet, the engineering that goes behind some of the spam blocking already exists. So it's not just the spam filters on your personal software on your computer, but actually within the network. And there are lots of those kinds of examples that happens. And the point I was trying to make was, if that technique is already being used in some instances, the question isn't whether or not this breaks the internet, because the founder of that system says it doesn't break the internet. And if the internet breaks, it fixes itself every day because it's redundant. It's whether or not you apply it in a different context, and that's really what this boils down to.
I want to raise maybe Mr. Clemens, or maybe it was Carl's question, which is, what difference does it make that we become a nation with two different kinds with industries that are split? It's like the sheep and the cattle in the West. That public debate changes when there are strong forces on two sides of the side. So here we have the Google side. I may differ on how important Google was. Google versus content. So that is, to the extent this is a debate among strong forces, corporate forces, with different positions, is that one of the takeaways of this debate, that presents certain challenges for Congress that are different from when everybody sits around the table and agrees?
I think it may. I think that what's important here is that, it's easy to pit, industry on one side, sort of the media industry, and then and the tech industry. And the truth of the matter is, there's a lot of convergence happening on a number of fronts. Media companies want to be on the internet, so everyone's saying, oh, they're scared off and they're beaten into submission and they're coming into the internet and licensing people finally. Nothing could be further from the truth, because if you talk to our marketing people and the marketing people at any media companies, they want to be where consumers are. But we also have to do it in a way that makes sense business-wise. Part of that is business models, but part of that is also, your relationships and contracts. If you don't have any contracts and have no constituency, you do what you want, and the consequences, may end up with a legal action or not. But when you have all the relationships and contracts of, say, a large studio, and you violate those contracts, you will certainly end up in a court action. And so there are lots of different responsibilities. One of the things in this debate is you had a side with a core constituency, and it was a smaller, so I would call the media companies smaller in this instance because of all the other groups that came out against it on Sopa and Pipa. And you have a lot of groups that don't have necessarily the same types of constituencies. And so if you're not worried about how you promote something on the internet, or what contracts you may violate, or how you impact all of your relationships, it's very different, because you can go out, use a lot of passion, and argue against something even though you're not for something. And I'd say that, that's in part what happened here.
Craig, do you want to comment? You have a question? Yeah.
Yeah, I mean, I guess I would just say I feel pretty bad for the small media companies who lined up 41 votes before the public debate in the Senate before the public debate started. And it's a little hard for me to accept that Viacom or its allies were the little guys in this debate. And I'd be happy to compare and contrast lobbying, spending, and other things. Anyway, I think what I do worry about that clash of the Titans frame, though, because I think, if this whole debate boils down to Viacom versus Google, it's sort of like two wolves and a sheep deciding what's for dinner, and the public is the livestock. And I think that, my concern is that out of this, that too often the public, informed or as misinformed as they may be, and we can debate that too, isn't included in these discussions, and it's seen as just something that should happen behind closed doors. I welcome this discussion. What should come first? How should we talk about copyright? Have the norms changed? That's a very interesting public conversation. It'd be really interesting if we actually.
I'd like to ask Mr. Clemens' question, which is this? Do you think one of the problems here was lack of confidence that the IP law itself has the integrity that it should have? That is, say that the last 20 years have produced an intellectual property law that has some problems deep within it, and then adding the layer of Sopa and Pipa, we're not ready for that. That is, say that it wasn't explicit, but that somehow deep down people were saying, well, is this really the intellectual property law that we want to have more grandly enforced?
I don't know that Sopa and Pipa are, I know we're calling it different, Pipa, Pipa.
Whatever.
Right, I'm just going to call it Pipa. I think this was very specifically about enforcement of certain laws. And so I don't think this was the place to debate, the term of copyright, whether it should be life plus 70 or something else. This wasn't that moment. This moment was about people are offshore,
No, I mean, is there, in the underneath it all, because what brings all these people out is some vague distress. And the question is it distress about the IP law itself? So you can, I agree with you that this debate was about what it was about. But did it shield a larger set of concerns? And you're taking the position, no, it didn't. It just was about Soap and Pipa.
Can I push on that for a second? I think that when the American people believe something, a law to be wrong, it becomes unenforceable. And that's one of the reasons why prohibition didn't last. I think that Pipa and Sopa were attempts to fix a real problem, which is the abuse of intellectual property. But this wasn't my idea. This is actually the idea of a Penn law prof, who said part of the problem, part of the reason you need so much more enforcement is the IP laws as they exist today are not seen as legitimate. And I'm actually running with Sean's idea, which was that if the law were adjusted in a way that more of us were sympathetic to, then enforcement would be less of an issue because compliance would be greatly enhanced. Now, I'm not sure, listening to Craig and Stan, how close we are to coming up with something we would all agree on. But if we had something we all agreed on, like thou shalt not kill, there's a whole lot less murder going on that can be attributed solely to the presence of policemen. If we all accepted that certain kinds of IP reuse are creative and other kinds of IP reuse are theft, I think we would still need a Sopa, a Pipa. But I think there would be far less violation going on. And what I dislike, and I think Craig and I agree on this, what I dislike about those laws is not, in my case, that I don't think we need laws. I think we need laws that are unambiguous. I read and I'm not a lawyer, I read this 2 or 3 times. I couldn't figure out what protection a website had if accused. I think that stopping a revenue stream is a perfectly legitimate action against a content thief. But I couldn't tell how the bill determines. So just to be really, really brief, one of my points was we would need less enforcement if we did more self-enforcement because we understood that copyright was in everyone's best interest.
Okay, we
The
have a
other
couple-
is, I don't like these laws because I don't know what they mean, not because I don't think laws are necessary.
Right, just
I think we should just take one of these at a time, and also we should take some more questions. So you want to respond quickly, Stanley?
yeah, just on the vagueness point, I think you,
I'd rather stick on the, is there a problem with IP? I'm trying to move beyond the law
Sure,
itself
sure.
to what are the undercurrents that led in one direction or another.
I guess I didn't view the problem here as one of IP. Maybe we're talking about two different things, actually. There's the impetus for the bill, and then there's the reaction to it by a large number of the public. And a lot of it was very focused on the bill. You didn't hear a lot of other noises. A lot of it was, this provision's bad, this does something or other. I don't remember like a lot of discussion about term extension. Right.
Well,
It was really.
This may be one of the problems. This could be a problem of what you hear, I think, but that's a different question. But let's get some comments. Oh, you're first, because you're.
So my question was kind of answered.
We'll collect them, by the way.
By Eric. Where my question is the fact that we have two people sitting up here who can't agree on what the bill said. And I watched a live stream of the congressional hearings, and the congressman arguing about the bill and debating it couldn't agree with what the bill said. And they were talking about IT professionals and people who built the internet, and they couldn't agree with what they were talking about. And I find it hard that we're basing our legislation off of these documents that I attempted to read, and I find myself to be a well-informed citizen who should be able to read what laws are being put into bill, what bills are becoming laws. And I found that I couldn't discern it. And I looked to other media outlets, Free Press, I looked to the Huffington Post, I looked to other media outlets who were looking at the bill and saying, this is what the bill is really saying. But it's obvious that it can be it can be interpreted in many different ways, and I find that that is probably the problem. Do you agree?
I think that is one of the problems. Like, for instance, in my mind, saying that Twitter could go out of business or Facebook does violence to what the bill is supposed to do. But clearly others disagreed with that point of view, because this was really targeted. And should the language have been clearer? Apparently, right? Because people can't agree on it. But the goal was to focus on these offshore sites. And they're supposed to be dedicated to infringement, right? So when someone's concerned about one bad clip on a UGC site potentially taking the whole thing down, what that says is the debate's been shifted in the wrong direction, because the focus was on dedicated to infringing content, not one bad clip and you go down. And so somewhere in the debate that became a message point, and that's a problem, because if the goal is focused on offshore sites, but everyone we're talking about here is talking about, legitimate U.S. sites, then, that means the debate steered in a different direction. So, should it have been clearer? Probably. But the focus is on the offshore problem. That was the enforcement problem they were trying to address.
Comment? Question?
I think it was Kartik mentioned something earlier, how legislation isn't necessarily end-all be-all solution to the IP piracy issue. He also mentioned the idea of the possibility that marketing for these properties might help resolve some of the issues. Does the rest of the panel agree with this issue? And specifically to you, Stanley, is Viacom, our major media companies, looking at marketing as a possible solution instead of just relying strictly on the legislation?
Oh, absolutely. One of the things I was trying to say before about convergence is we're always licensing out. I mean, that's what we're doing. And so we're on a bunch of sites. We're not only on iTunes, but we're on Hulu. We're on the Netflix. We're on the new Netflix service. Paramount Movies actually started its own site as well, streaming service. So there is a huge effort to license out, and that's been the case from the very beginning. Like I said, where consumers are is where media companies want to be, because that's where you can reach them. But you also have to figure out a business model that makes sense. You don't just put it out there. You've got to figure out a way to make it work financially. And so I think that's the number one goal of all of this, is to try to create a fair and balanced marketplace that you can compete. So, if we put up a business and it fails against Netflix because we're competing head to head, not that we are, but if we were, that's competition. But when someone else can take all the content, no licenses, base themselves offshore, and offer those services in a clean website and then charge people actually subscription services for it, we're not competing on a fair. So I think really at base this is about winning in the marketplace. We're talking about it in a very legalistic and constitutional and norms framework, but at the end of the day, this is about a business proposition and trying to level that playing field.
In fairness, Kartik did say market solution, not marketing solution. And in fairness, one of the things we've known about markets for well over 100 years is problems with things like externalities. Markets don't take care of pollution because the damage borne by pollution is paid by the people downstream, not by the consumers or the producers. Markets don't take care of free riding, the tragedy of the commons. If everybody else is paying for content, it really doesn't harm anybody, really, if I steal. But if enough people say it doesn't harm anybody if I steal, the market collapses. I don't think Kartik is a full libertarian on this. Kartik did not say we don't need law. Kartik is saying we need a combination of law we can believe in and a market that respects those laws, which is not unrelated, I hope, to the point I made, which is if indeed we respected IP more, we would probably abuse it less. Stan, does that make sense?
Oh, yeah.
But I guess I didn't just throw in too. I mean, I agree with all that, and I probably come down a little closer to the side of, you know, that the rules and laws really matter and creating that even playing field, which we may not even disagree on. On the other hand, if we're looking at sort of market solutions, I mean, I think there's some interesting things happening in the market here that companies are going to have to respond to. I mean, I'm a little facetious here, but if Mega Upload was making $175 million, you guys should buy that. You know, you should be investing in, not in stealing content, of course, but in, you know, in seeing where the market's going. And I bet a lot of people who are very interested in not doing business with the Kim.coms of the world would welcome, you know, services offered at a fair price for the things that they're looking for and to do it legally. And I think some of that has started to happen, but I would argue that a lot of the companies have been somewhat late to that game. Apple's maybe an exception. And that they need to see where consumers are at as well, and perhaps take a less punitive approach to the customer in these cases, even while dealing with the, you know, the mega uploads of the world.
I just want to spend 60 seconds on the mega upload just because.
Okay, and then, wait, and then, because
I want 15 seconds. We'll definitely take questions, I promise. So the way mega upload worked, I don't know if both of you used it, but the way it worked was you as the consumer uploaded the movies. Right? If they didn't go out and get licenses, they didn't grab copies. Sometimes they actually went on to iTunes. I mean, they went on to YouTube and made copies of works from that streaming service, right, and put it onto their site so that they would have more content. But they really encouraged users to upload. And the way they did that was a few ways. One was they'd give you storage space when you uploaded. The other thing was if you got more people to link to your content, then you could generate a point system with reward points, like American Express points. You got points for the more people who pointed to you, and you get to linking sites and they point to you. And so there's an encouragement of everyone going out there without a license and putting it up. Then to access the system, you had a very limited pipeline, call it like a slow straw. If you wanted more, you'd have to buy a subscription up to, I think, 49.99 euros a year, and then you get all the movies you wanted for free. That's basically the business model. Then they served ads against it, so they were getting subscription, they were getting ad revenue, and they were crowdsourcing their movies and their television shows. And they took up 4% of the worldwide internet doing that. Now, how would we go about doing that? Well, first of all, like we have a deal with Netflix, that was a tough negotiation, right? They license it from us. If we want to get something from someone else, we want to make a movie out of a book or what have you, we've got to license that from someone else, and that's the nature of the business. Now, to just acquire like a mega upload means to acquire this trove of content that's completely free and clear from any protections and for really any clear from any licenses. And so while it is useful and we do gain a lot of information from studying anti-piracy patterns, right, because we understand where people are going and what they're interested in and what scenes they like, you can acquire that information. The core of that effort is really not to build a business, but to stop someone from taking yours, because that's essentially what's happening. And so while it's interesting and fun to think about, oh, just acquire that business, a lot of business models actually, you know, prop up on that. Like mp3.com built their business on the assumption that they'd probably get sued, and they would just pay their way out through settlements, and that would be their negotiation. You know, they were sued, they lost the case, and they settled some cases, and they had a judgment against them as well.
60 seconds.
Yeah, and so all I'm saying is that's not a business model that we acquire because that just invites a lawsuit.
Okay, I just want to get these.
No, I can do mine in 30
Okay.
seconds. And mine is, although I know Craig was being facetious, but to suggest that a media company buy a theft company is like suggesting that a Mercedes dealership buy the guys who break into Mercedes to steal the radios as their radio supplier. It's not a fair comparison. One is a legitimate business with real expenses, and the other is a very different business.
And I just to be clear, and I was being facetious,
No,
as far as I know.
But can I just get the two people who want to comment or question? Yes.
Well, the question I want to ask really is to pursue the point that you made at the very beginning, and that is in the discussion of how to manage the market in a legitimate way and to keep unauthorized use of property from happening. How do you separate that from what looks like to other people? I mean, how do you separate that from the political unintended consequences of the same kinds of mechanisms being used to move against what are considered to be unauthorized political opinions? I mean, I think that's a real fundamental concern out here.
Are you focused mainly on political opinion, or?
Well, in other words, if it's possible to move against, sorry, if it's possible to take down sites because they are doing the wrong thing in terms of their use of property that doesn't belong to them, then what are the possible what are we going to do about political sites that will then be taken down for reasons associated with property, but the real intent is to limit political expression?
So you're worried about the slippery slope. If you
Yeah,
start here, what's going to happen down the pike? And I think that's always a concern with lots of different kinds of laws. I think here the effort was to have something very targeted so it didn't slip into that. So that's why it was focused on, nothing political or free speech oriented. I mean, this was really focused on sites that were dedicated to taking content. And so I think part of the story here is you've got to explain that a lot better so people get it. And maybe you still have a debate, maybe still, people still oppose it, but at least you get out like what is the core of it and what it's not. I mean, talking about what it is one thing, talking about what it's not is another. And it's not the things you talked about, right? But how do you explain that it's not a slippery slope, that you're going to all of a sudden end up taking sites down because of political speech or because of some other mechanism?
Well, you might not.
I think
Other users are not, other operators are not so nicely motivated.
Right, and I think that's the important point. It's not about a slippery slope. It's about your intention versus the intention. In a bill in which language is just so vaguely drafted that someone else's intention could be to misuse it in a way to censor perfectly legitimate content. And maybe they would be unsuccessful in the end, but as Craig pointed out, it might take a year before that case works its way through the system. And the language in the bill said that your threshold for suing back, that's the other thing. It's like maybe you get your site back, but can you sue them for damages? And only if they knowingly, materially misrepresented the theft. And they could say, well, we really thought it was, we didn't know, sorry, it was just our error. Rather, of course, it's going to be very difficult to prove that they had some sort of nefarious plan. And I think that's the point of throwing the entire baby out with the bathwater, and that I think fundamentally is what this debate was about.
Okay. Do you want to talk about the baby or the bathwater?
I actually could just
Wait.
really very, very quickly. One of the hardest ways to have somebody take away your right to say something is fair use is if it's politically motivated. Politically motivated speech is one of the most protected things in the United States. I don't see a slippery slope here. I think your point about a really bad bill and arguing something is scary. But I don't think there's a slippery slope to take away your First Amendment.
I think the slippery slope argument were two things. One is that it legitimates conduct by other states against political speech. And the other one is that it's the Scientology argument that there are occasions in which intellectual property and content uses are conflated in some way and enlarges the opportunity. And then the third thing I'd say is that all legislation has a slippery slope. They all have mission creep. The idea that you can confine statutes to the precise language that it is housed in would be great if we were all great draftsmen and interpreters, but we're not.
And I think it's not just political content. I mean, it's any kind of content that someone could have a beef. You know, say your ex-husband suddenly gets angry at you and sues you. I mean, you know, there's all kinds of content. It doesn't have to be political speech that I think could get caught up in that net.
I do think so. The other thing is, I mean, just as I talked about convergence on technology and IP and sort of the media side and how we're on both sides of that, we're also both sides of the issue. I mean, we put out Jersey Shore, right? So, I mean, we're clearly in favor of free speech in a lot of what we do in all of our programming. So we have to live with all the consequences of these things as well. And it's not just like there's one side or the other on these things.
I think this picks up on both Professor Marvin's point and a couple of the points that were made here. And one of the things that I heard coming out in a number of the talks, which were great, is the notion of maybe a hierarchy or at least a spectrum of different types of content. And we kind of heard about it in terms of the democratic value versus the entertainment value of content. We heard about it a bit in terms of the cost to create the content, the power of the owners or the creators of the content, and then the sort of time scale of sort of how long that content should be protected for. And I'm wondering if you could talk a bit about the extent to which Sopa, Pipa, or the Digital Millennium Copyright Act reinforce these types of hierarchies or create these types of hierarchies, and if these hierarchies are necessary, or if they create a problem, which I think is one of the things that Dr. Marvin, her question was getting at.
I think we're all looking at each other because we're like, what does that mean?
Say a word about the hierarchies that you know.
Yeah, and I think one of the things that was kind of interesting was the different types of content that each of you kind of thought should be protected, and were using as examples of speech or content that should be protected. And I think it was different for each of you. I mean, I think, Mr. Aaron, you talked about the footage of revolutions versus sort of more entertainment-oriented content. And I've heard Professor Clemson talked about sort of New York Times content, which has a sort of very short shelf life, versus forms of content that have longer shelf lives to be protected for. And I'm just wondering if these bills or laws kind of create those types of hierarchies, have those types of hierarchies embedded in them, and if that is necessary.
I'm going to introduce an idea that's related to this, and that is a theory that I've wanted to develop and I haven't, which is that industries get built on taking content from a previous industry. This is the hierarchy of the over-the-air channel debate with respect to cable television. So the cable industry in the 1960s and 70s, said there's something called over-the-air, and we can take it down because when we grab it in the satellite, we don't have to pay the broadcaster for it. And this was a debate which built an industry. The whole industry was built on taking material that the broadcast industry thought should be protected. The question is this a paradigm, or was that an exception? But in some odd way, the echoes of that are really interesting in respect to this current debate. Not that theft is good or bad, but how industrially, this goes back to the development of copyright in the United States with respect to material that was in the public domain, but protected in the UK, Dickens, etc. So is there a pattern of industries being built by taking material at a low cost of entry and coupling it with new technology? And
it doesn't even need new technology.
It doesn't need new technology.
Think of hot news doctrine.
Of what?
Hot news doctrine, a newspaper that decides it's cheaper to get its investigative journalism from a competitor who did it over the course of 6 months and then rewrites the story in its own words and publishes 4 hours later. The idea that once it's out there is really attractive, and it's been attractive to the media industry and media parasites for centuries.
Well, we could ask whether Viacom was built on the intellectual property of the broadcast industry.
I mean, I think for, the Viacom that I know, at least, I don't know, we do a long corporate history. But I think in relation to what you're saying and to the questioner, the law kind of puts everyone on an even footing at the beginning, right? So you create the copyright and it has certain protections. But then there are some values assessed, particularly in fair use. There's this test where you weigh certain things, and so fact-driven things are probably less protective than complete sort of fictionally created things and how they get assessed. So that happens a little bit. But I think some of the examples you're hearing about are probably, they're interesting because our focus, at least in thinking about this, has been on primarily people taking full copies of programs or largely full copies of programs that were created and invested in and all those things. And then there's the citizen journalist who's out there doing something. And in order for that to come down and be considered infringing, you as the owner of that work need to say, hey, that's a problem. And so I think in some parts, I think what Craig was talking about was not that person seeking to remove it so much as the consequence of being on a site that gets removed. And so it's sort of the consequence of being on a site where infringing conduct occurs. Now, the goal of the bill, at least in this context, was to focus on sites that were really dedicated to infringement. And so, at least the way I would think about it, there wouldn't be many instances of them being in the same place. Now, we can debate that, right? We can debate whether I think it needs to be 99% or 51% or whatever that is before a trigger happens. But I think that's the essence of the debate, not so much whether it's infringing because some people may want their works to go viral, right? That's what Twitter is, right? You create these 140 characters and you want it to get retweeted. And so there are certain platforms and norms that people expect virality to occur, and there are some where people don't. And I think that's part of the tug of war.
And I mean, I guess what I was getting at, and it obviously does in some senses boil down to this disagreement about what the bill said or didn't say or what doors it opened, but was a concern that in addition to the potential that there's legitimate or important content on the site that gets taken down, is actually that under a law like this, that a site that includes user-generated content in trying to avoid the sanctions in this bill or the lawsuits or whatever would be really going out of their way to stop anything that might be anywhere near that line, and that's where it can run into political speech. I mean, even under the MCA, I can think of instances where we've done political videos pointing out the behavior of, say, a broadcaster who then files a takedown complaint with YouTube because we showed their logo. Now, I work with a couple lawyers, so we can fight that, but for a lot of other people, they're not going to have that opportunity. And so in terms of, I guess, the unintended consequences of this kind of legislation, those are things that I would concern.
Did you have a question? Or do you? Okay, yes.
So, Alexis Ohanian, one of the co-founders of Reddit, said something very interesting, to paraphrase it, that the problem is not the fact that people want to steal and it's the money. It's the fact that it's easier. The fact that and I would take that so far to say that it wasn't the lawyers that took down Napster, because they took down Napster and then Kazaa and LimeWire and BearShare and all the other ones popped up. It was iTunes that killed it, because iTunes made it easier. People didn't mind paying 99 cents for a song. People were annoyed that they had to go to the record store and purchase a CD. And now I feel like I don't know anybody who steals their music because iTunes is so easy to use. RDO and Spotify are just so easy to use that people are willing to pay. Now, the same is not as true for TV and movies. And I can understand that the production cost that goes into a movie is far greater than an album. But I still see South Park every single day after new episodes. The episode is up on the internet free to stream. Colbert Report, Daily Show. They're Viacom entities. The shows are up on the website, for people to stream and view freely, and I can guarantee you that nobody is stealing that content because it's free. Now,
I bet the commercials are still embedded in it.
they are, but I don't mind watching.
No, that's
yeah.
the point. What Viacom has done is found a way of legitimating their content by saying you can have it in real time as long as the terms are the same as the terms you would get watching it. What Apple has done is re-legitimated IP by saying we'll come up with a convenient, fair pricing mechanism. We'll actually let you have multiple copies from multiple devices so you don't feel like a felon listening to music you paid for. And what you're saying is, if Kartik didn't have a class, Kartik would say, I told you so, because you're proposing a marketplace solution. And it's a marketplace solution that re-legitimates IP.
And I mean, that's what I was in my perhaps ill-advised mega upload joke. I mean, that's the point, I think, is that, you know, these companies do need to, and some are, you know, adjust to where their customers, how they want to get content, how they want to experience that, and that most of those customers, and maybe not all, but most, and a lot to make plenty of money, if you offer, you know, what they want at a reasonable price, are happy to pay that price.
I wouldn't say that you can't guarantee me that no one still steals it.
No.
But
we can never.
But what and we know this because we look for it and we find it, we take it down. But having, I think it is, your point is well taken in that having that argument that it's actually available in a way for consumers to get it on a variety of different platforms. There's a pay model, there's a watch and ad model, there are clip models, there are all kinds of models that we have, and for a large portion of our content. It makes it easy to point to as a solution. And that's why, I mean, we've been on both sides of fair use cases. Like, you know, we've sued people and we've been sued. We have shows that rely on fair use. So we're really like we really are trying to embrace a lot of the technology and consumer habits and trying to harness it. Sometimes you try to steer it with your programming. Sometimes you try to sort of harness it or get in front of it or ride the wave, whatever that situation entails. But that's ultimately where I think we want to end up being, is where consumers want to be. So if you're on your iPad, you want to be on your iPad. And I think when you have that as an argument, you know, it's a nice counter. So we're not just saying, no, don't do this. We're saying, here's a positive way of viewing the content as well.
Can I ask Santa just a quick question?
I think we're going to have closing comments unless there are other questions. So consider this your closing comment.
Well, it was actually just a question because it's not a leading question. Actually, I really want to know the answer.
Isn't it true?
So many folks have pointed to the mega upload situation as an example of why we don't need a Sopa or a Pipa. That we actually have laws, and you know, most nations can work, you know, collaboratively or cooperatively to take down these most egregious actors to the extent that you believe mega upload was, and I'm not questioning it. Although some have. So I'm wondering if you could respond to that.
Sure. That's I'm glad you asked it. That's a great question. So the question about a mega upload isn't about whether or not we could have sued them in the U.S. Right? It's a question of could you have enforced a meaningful judgment against them. So you've got Kim Schmidt, Kim.com, whatever his name is, dual citizen of Germany and Denmark. Who founds a company in Hong Kong, owns a place at the Four Seasons there, and currently rents the largest house in New Zealand, and happens to have a large number of servers in Eastern Virginia, right, which gives them, you know, some access in the U.S., some jurisdiction in the U.S. Bank accounts all over the world. Take them to court, we win, great. What do we do? And that's, I think, the question that Sopa and Pipa were trying to address. What do you do when you get a $100 million judgment against the guy? And I guess we spend years trying to coordinate, because this is a federal action, right?
And the site's down. I mean, it's gone.
No, but it's down now. But if we had sued them, like, where do we enforce that judgment? How do we get that done? Where you know, that's the big issue. Is if he's all around the world, and if he's got service not just in the U.S. but in Sweden and in Hong Kong and all over the world, how do we enforce it? And so Pipa wasn't about whether or not we have the right to sue him or have jurisdiction on him. It's whether or not you can enforce it. What you would do there is not shut the site down, but actually block access in the U.S. And stop the payments from U.S. like the Visa and PayPal. So that was the question I was answering. It wasn't whether or not we have the right or authority to do it. It was whether we have a meaningful enforcement judgment. And if you look at how this went down, you had multiple jurisdictions working with the federal government over 2 years to do this. One private company is not going to be able to do it by itself. And then even if you win that case, trying to block it, what do you do? And so I think that's it. It's how do you block access to that site once you've prevailed and it's been found to be infringing and the like. So does that make sense?
It's interesting that there is a case, I'm trying to remember the facts of it now, in which, maybe you know, Craig, where it's either a Holocaust denial, it wasn't a Holocaust denial case, but it was some case in France in which we basically don't like the French law. And there was a statute passed that says you can't enforce these statutes in the United States. It was the opposite, like we don't like your law, so we're going to preclude you from being able to enforce it. So I'm trying to think of whether they're two ends of a bookend, two bookends, as it were. One is, the question is, are we saying we should be able to decide how to enforce conduct that takes place elsewhere, but we're not going to let other people enforce in our jurisdiction judgments that we don't like. And, this is a real problem in general.
I think we're saying the opposite. We're saying do what you want in Hong Kong, do what you want in Spain, do what you want in France. When it comes to our borders, there are certain things we respect and want to protect, and we don't want them down here, whether it's a physical border or an online border. But it's not saying we're going to shut you down. It's saying we don't want that happening here. So it's more defensive, really.
Right. I think it's about enforcement.
The other uses it as an argument in a reciprocal way. You could have, I think that's your point.
Right, but I think they're doing
just
that.
Some irony
here.
I don't know what it is, and I don't want. I'm not saying
that already happened. So I don't know that this bolsters it.
Nobody is going to argue that censorship in Syria or censorship in Egypt was justified looking at an early draft of Sopa. It just doesn't make sense. I don't want that to be my closing statement, but I'm willing to live with it if the moderator wants
Can I
it to
just
be.
one quick
Sure.
question? Because
We all get
the
closing
comment from the audience about the fact that fewer people are actually stealing protected works because licensing has made it easier so we can download it legitimately and pay for it. It seems to me provides some support to Kartik's suggestion that some kind of system for these UGC sites that would be monitored might be an effective mechanism, and I'm curious what any of your reactions to that is.
I have two things. One is, it's hard to tell whether the rate is up or down. We don't have to have that debate about whether people check. I do know that when you provide people with more legitimate avenues, it creates more opportunities for legitimacy, legitimate markets to grow, and that's what's really important. That's a critical element. I totally agree with him on the part about trying to have creative ways of blocking it from happening, right? It means litigation doesn't have to be the first and only solution. So Viacom, for example, was one of the founding members of a group that put out something called the Principles for UGC Sites, right? Which looked at sharing the burden. I think he had set it up as, well, one side has responsibility versus the other, and that's what this fight's about. And we've always taken the position that it's a shared burden, because that's what the DMCA requires. And so the obligation on the part of the groups that own content would be to help create those filters, help create the content, because we do know that content, we own it. And so we would help create those filters, and or at least we would help in populating the filters. And the companies that run UGC sites would use that fingerprinted content to block uploads. And that's happened quite successfully, as you saw, as you heard about in some of the stats. Different sites had different success levels, and their incentives were quite different on how they enforce. But that is a mechanism. But I do agree that the market-based solutions, whether it's having something defensive like the filters versus having market-based platforms, are key.
I thought what he was, obviously, what exists now works sometimes, but not always effectively.
And so you're saying is the auditing of it?
I thought what he was saying was that if you actually then monitor this, you would create an incentive for it to work better more of the time.
No, I think that's right.
And then who would be the monitor?
Since Kartik isn't here, I'll give his closing statement. I think Kartik made 2 points. And one point, I think, came out in the discussion of Viacom making things available to users, Apple making things available to users in forms they want. That's part of a marketplace solution. The other part of a marketplace solution is re-internalizing the externality. Anytime you find somebody for polluting a river, you're re-internalizing to the polluter the cost of the pollution. And I think what Kartik focused on was that it is possible to do a much better job and prove that you're doing a much better job with protecting other people's property. If he were still here, he would acknowledge that you have to provide incentives for doing it. It's not just enough to have technology. It's not just enough to have the technology audited. There has to be some form of re-internalization. There has to be some penalty to violation. And I think that by the end of the 2 hours, it sounds like we're all in agreement with that. What we're actually debating is how extreme that punishment can be without being a stifling, chilling effect on free speech. But I think Kartik would feel really good if you were here. He would say, yes, we've agreed with the market can deal with a lot of it. Yes, we've agreed that the technology can deal with a lot of it. And yes, we've agreed that we need to give the marketplace some incentives. I guess my closing remark should be, I wish I'd had something as clever to say as what Kartik said.
I'd sort of like to leave it on that note. It's a wonderful note to end on, and I think it demonstrates that there's a lot of interest and there's a lot of willingness to work together on some things if we can only find a common ground. And that should be true of our national public debate on a number of issues. So thank you very much. And I want particularly to thank Stanley because it could be perceived as a hostile environment. I hope it has not.
This is like home.
Okay. Thank you.
Thank you, Pat.
Thank you very, very much.